We have 760 participants who registered. At the moment, we have over 300 participants. We really hope we get up to 700, if not even more than that. And those of you who cannot join, please do join our Facebook page where you can watch this thing live. I will give the link to everyone in here. I've also put a link in the waiting room. So those of you who are here and you have friends who are telling you they can't join because they can't get in, please let them know this is the link to go to and you can watch this live. I think Professor Andrew was saying that this is the most number of people he has been in a talk where participants are involved in terms of Zoom. And I think this is really a testament to how important this topic is for everyone who is here. This topic is obviously something which is very dear to everyone's heart. SLS, sorry, all of you who are here, if you can turn off your videos besides the speakers, and also turn off your microphones if you could please, because it does disrupt a little bit. And later on, what we will do is we'll ask people to unmute themselves, as well as to show themselves, but that's later on when it comes to Q&A. Okay, so those of you who are coming on, please do switch yourself off in terms of video and your microphone, okay, so that we don't get disrupted. Okay, so as I was saying just now, SLS basically strives to bring quality talks to everyone on current affairs that matters to our members as well as the public. And it is hoped that today's forum will be just such a talk. When one thinks about Star Wars, you think about Luke Skywalker, Darth Vader, Yoda. And when one thinks about Egypt, we think about the Great Pyramids of Giza. So when we talk about MA63, who do we think about? Immediately, we think about people like Dr. Professor Shad, Professor Andrew Harding, YB Baru BN, and Professor James Chin. All of these people come to mind. So today, we are very, very fortunate because we have all of these brilliant, brilliant speakers who are under one roof for the very first time. They have done talks themselves individually or in pairs or whatever, separately in different forums. But this is the very first time that we have gotten all of these speakers together under one roof. And I think it is going to be a blockbuster. I call it a blockbuster because it is, of an event where all of you can share in the thoughts of these very learned people who have delved a lot into this part and into thinking about how we can make best of what happened on 15th of December 2021. Just very, very briefly, I won't go into it because everyone else will. On 15th of December 2021, basically Article 1(2) of the Federal Constitution was amended to essentially put back Sabah and Sarawak into one of the partners that form Malaysia. And what does that hold? Is that sufficient? Where do we go from here? All of these are basically things that will be addressed today. And it is hoped that from here, we learn about where do we go and what do we do with our future. Just a very quick note before I pass this to the moderator, Dr. David Fong. Unfortunately, Professor Shad is not able to be with us today. He's unfortunately feeling unwell, but don't worry. Dr. David has kindly done some desperate measures to learn his slides, and he will be presenting Professor Shad's talk. So you have not missed anything except that you haven't seen Professor Shad. I'm sure he will talk again for us at another time. But with that, I pass it to Dr. Fong to introduce everybody. Thank you everyone for joining SLS, and we look forward to bringing you even more talks.
Thank you very much, Roger. Yeah, we are all eagerly expecting to hear from our speakers. Fortunately, Professor Shard could not join us. Our prayers with him and well wishes for him to recover quickly. Now, I will introduce the other speakers now. You could see on the screen here, Professor Andrew Harding. And that name is no stranger to all of us because he's written books on the Malaysian Constitution, the latest being the Constitution of Malaysia, I think, in hard publication. A very good series of constitutional law books covering all the countries. Now, at the moment, Professor Harding is a visiting research professor at the Center for Asian Legal Studies, National University of Singapore. Glad to have you with us, Andrew. Now, next, of course, Professor James Chin is speaking to you from Tasmania, right? Okay, so, and we all, I know it's close to his dinner time, but he will be presenting to you, but this will be from the political side of the MA 63. And Professor James is a professor of Asian Studies at the University of Tasmania. You would have known him through his writings in the national and local dailies on Malaysian politics, especially when election time is here. Now, last but not least, we have YB Barubian from Kuching, Sarawak at the moment. Now, YB Barubian is no stranger to us. He's a well-known public figure. He's a member of parliament for Selangan, Sarawak, member of the Sarawak State Assembly for Balakalat, and he is also now a former Minister of Works, the previous government, 2018. Now, he is a native of Sarawak, Lumbawang, right? And an advocate and solicitor for the past 30 years. You would have, those who are lawyers would recognize his cases, right? The landmark case of No Anak Niawi versus Borneo Pulp Plantation, reported in 2001, is his case. Right? He ran the case right up to the federal court, fighting for the native customary rights. So now, with all that, I think what we'll do today is this, right? The speakers will speak for about 10 to 15 minutes, about 15 minutes, right? They will cover different perspectives of MA 63, the road ahead. All very interesting. Now, they will speak first, one after another, and then when we have finished, it will take us to probably the hour mark. We will have questions and answers. So note down what you have in mind when you hear them, and then we will deal with the many issues actually that we have on this topic. So with this, I shall begin. And I have to say I'm a very poor substitute for Professor Shard, who is the chair of the, I'll get his slides up, of the Tunku Abdul Rahman Chair at the University of Malaya. And we will start with him because he will lay the foundation for what we have to share today. As you can see here, Professor Shard is Emeritus Professor, Tunku Abdul Rahman Chair, Faculty of Law, University of Malaya. He has spoken on this many times, and he's going to cover this topic, a step towards redemption or mere symbolism. These slides are prepared by Professor Shard. Yeah. Okay. I'll start now and summarize in many ways his views. Of course, it has we do welcome the amendments, which as Roger mentioned, came through, the Constitution Amendment Act, and there are four provisions, right, in this amendment, two of great importance and at the same time open to great contention. The Federal Amendment reverts to the constitutional provision of 1963, when the territories of the Federation were described in three separate categories: states of Malaya, the Borneo states of Sabah and Sarawak, and Singapore. Though the amendment confers no additional rights or powers, it has significance because it recognizes that Sabah and Sarawak are special and have different autonomous asymmetrical position in the federal setup of Malaysia. The autonomous asymmetrical position was immediately asserted by Sarawak by amending its state constitution to redesignate its Chief Minister as Premier. Now, this poses no legal problems because Article 162 of the Federal Constitution defines Chief Minister as the President of the Executive Council by whatever style known. This is a topic that Professor Shah is going to deal with now. And that is, we have heard very often spoken in the press about the fact that Sabah and Sarawak are now equal partners to the Federation in the Peninsular States. But you would know that the amendment nowhere divides the country into two equal regions, Malay states and the Borneo states. Now, it is noteworthy that in some executive, legislative, judicial, and financial areas, Sabah and Sarawak are not equal, but more than equal and enjoy autonomy and special powers not assigned to the Peninsular States. Actually, Professor makes the point that equality will actually be a downgrade because they are actually in these areas given special rights. From the point of view of legal personality, there is no separate legal entity called Peninsular States and Borneo States. Sabah and Sarawak and the 11 Peninsular States have their own separate constitutions, and along with the 3 federal territories, each entity has its own juristic personality. However, in some areas, Sabah and Sarawak suffer disadvantages compared to the Peninsular States. 1, Malaysia's head of state, the Yang di-Pertuan Agong, is by law always from the peninsula. In the King's election or dismissal, the governance of Sabah, Sarawak, Malacca, and Penang have no role. Now, in the Devon Rakyat, Sabah and Sarawak have 56 out of 222 members of parliament. West Malaysia has 166 out of 222 MPs. In the Senate, out of 70 members, Sabah and Sarawak has 4 senators, West Malaysia has 22. Additionally, there are 4 appointed senators. These are the advantages and the imbalance. Now, in the annual budget allocation, Sabah and Sarawak do not receive 50% of the allocation. Perhaps they should, due to their large territories and population, but no law requires that. For example, it's reported that in the 2022 budget, Sabah and Sarawak together received 9.8 billion development allocation compared to the Peninsula's 67.8 billion. Therefore, the popular notion of equal partners for Malaya is not based on any law or any historical document. In many areas, Sabah and Sarawak are more than equal. In others, they face serious disadvantages. These are the amendments. The definition of the term of the Federation. Article 162 is amended to redefine the term the Federation to acknowledge both the 1957 and 1963 Federation agreements. You would note immediately that it has taken a very long time, 58 years out of time. It specifically mentions the neo-federation pursuant to MA 63 agreement of 1963. Mention of MA 63 is most significant because it amounts to incorporation of MA 63 into our constitution. Up to now, MA 63 was merely an international agreement and thereby not enforceable in local courts. Now is upgraded to constitutional status by our parliament. Along with MA 63, the IGC Report 1962 is also indirectly constitutionalized, meaning it's been actually expressly stated in the federal constitution. The IGC report has 37 sections and 4 annexes and is rich with legal, political, and financial provisions which must now be taken note of as legal rules. For example, Section 26, 4 of the IGC states about the Supreme Court hearing cases arising from a Borneo state as having Borneo judicial experience. The judge should have it. This IGC prescription was rejected as having no force of law in Kurutum and Director of Forests 2018 and T.R. Sandal, Tabal Director of Forests in 2019. These cases will probably need to be reviewed with the amendment because now it's expressly stated in the federal constitution. Another provision not fully enforced is the federal constitution's Article 112C and the 10th schedule, Part 4, Section 2, special grants to Sabah and Sarawak. This particular paragraph of the IGC report calls for the joint appointment of the independent assessor for the purpose. Article 114, subsection 1, provides for the composition of the election commission. There's no requirement that a member should be from Sabah and Sarawak, but paragraph 25, subparagraph 1 of the IGC report requires that one member shall be from Sabah and Sarawak. I just pause here very quickly to mention that we mentioned the IGC report. This is the Intergovernmental Committee report, which is expressly referred to in MA 63 at Article 8. So that's why it is of quite critical importance. All in all, it appears that the passage of the 2021 amendment, the provisions of MA 63, the IGC report, and the vocabulary of Borneo states have been now constitutionalized. That is, they're expressly stated in the federal constitution. A new judicial approach is required for the interpretation of our constitution. The existing provisions must be reinterpreted, or interpreted as far as possible in harmony with these historical foundational documents. The federal constitution's definition of who is a native of Sarawak in Article 161, big letter A6, small letter A, and 161A7 is deleted. And the state is rightly allowed now to specify by state law who should be regarded as indigenous to the state. In immediate response to the amendment of the Federal Constitution, the Sarawak Interpretation Amendment Ordinance of 2022 was amended. These are the amendments. In fact, this is now the state matter. The important one is for Sarawak to determine the list of the 31 races. Now, children of mixed parentage will now be regarded as native, provided at least one is a parent. We move on to, now this may be shocking to a lot of us, but for the first time now, even though Malaysia has been in existence for more than 50 years, the term Malaysia Day, which occurs in the Constitution many times, but is not defined, the amendment now defines in Article 160 of the interpretation clause. This is the overview. And this is the question that you may be asking yourself. Is this a good first step? Or it is just mere symbolism? It's just historical, doesn't mean anything, right? This is Professor Saad's view. Autonomy and special rights of the Bornean states contain about 80 or so provisions of the federal constitution, and these need to be resurrected and enforced both in letter and spirit. The amendment to Article 1.2 is more symbolic than substantial and will not be the magic wand to resolve many woes which need additional measures. However, the Constitution Amendment Act 2021 is a good first step towards redemption of rights that were repealed or had not been enforced in letter or spirit. The list of litanies, that means unenforced promises or breaches that needs attending, is long and painful, and he lists them down here. Finances, there's a discontent about the inequitable sharing of resources, the lack of fiscal federalism. A major complaint is the meager 5% of oil royalties. Another major, extremely intricate complaint is that Sabah and Sarawak have not received the mandatory financial allocations that are due to them under Malaysia Agreement 1963 and Article 112C and 10 schedule. These are the provisions, and this is what is known to all of us as the 40% entitlement or grant. But despite the abundant natural resources and massive contribution to national coffers, Sabah and Sarawak rank among the poorest states in Malaysia and lag behind in infrastructure, education, and employment. Sabah has the lowest GDP of all the states in Malaysia, lagging well below the average. And unfortunately, 8 out of the 10 poorest districts are in Sabah. Now, amendments to the federal constitution. Federalization of critical state matters such as water and tourism have taken place. Article 1211 was amended in 1988 to emasculate the powers of the High Court of Borneo. The power of the governors to appoint judicial commissions was transferred to Yang di-Pertubuhan and Ogong in 1994. Federalization of Labuan. Borneoization of administrative services is proceeding too slowly. Now, the naturalization of thousands of illegal immigrants that has actually destroyed the special rights of Borneo states over immigration and incidentally also citizenship to Malaysia. Islamization, the moves towards an Islamic state. The plan is to introduce hoodoo laws. The attempt to export the peninsula's hardline Islamic trend aroused discomfort in Sabah and Sarawak. These are the representation that Dewan Rakyat at the moment. Proportion is less than the 33% envisaged in 1963 to give the states protection against amendments regarding 2/3 majority. Federal appointments. Despite Article 153, Sabah and Sarawak are seriously underrepresented in federal public services. The 20 points for Sabah, 18 points for Sarawak. Many of these have not been honored. Autonomy in matters of religion, language, and immigration have also been weakened. There's now a yearly controversy about the nation's age. Should be calculated from 31st August 1957 or 16th September 1963. But I think with the amendment, there should be no doubt. Now, this is the conclusion of Professor Shah. I think that as a matter of expediency, as well as matter of fidelity to the provisions of our 1957 and 1963 Constitution, the political leaders of West Malaysia must rebuild bridges of understanding with our brethren across the South China Sea so this federation can grow stronger. The amendment of the Federal Constitution gives hope. In a nutshell, his view is that it is a significant but important first step in the right direction. Now, with this, I complete the sharing of Professor Shah on his segment. Now it's my pleasure to introduce Professor Harding. All right, and he will be speaking to you from now on. Professor Harding, over to you.
Thank you very much, David, and thanks for the invitation. It's a great pleasure to be here. Let me just share my slides here. I hope you can see that all right. Since you are kind enough to mention my book, can I just indulge in a small commercial to say that the second edition of my book, The Constitution of Malaysia, A Contextual Analysis, is published on the 19th of May and is already available for advance order on the website of Hart Bloomsbury Publishing. So I want to talk about MA63 and decentralization. Let me just start by saying that I agree with everything that Prof. Shad says in his slides. I think the case for greater autonomy for Sabah and Sarawak is basically unanswerable. And I want to proceed, rather than justifying that position, to look at various constitutional and legal ways in which this aspiration might be fulfilled in practice. I'm going to stop short of making any comments about how to strategize claims in this area, because I think the next two speakers, Baru and James, are very well qualified, more so than myself, to address that question of political strategization. So I want to run through what I say are 6 ways in which Sabah, Sarawak, sorry, I've mentioned Sarawak, but every time I do that, I include Sabah because they're in exactly the same position constitutionally. So there are, as I say, 6 ways in which greater autonomy could be achieved. Now I want to just comment very briefly because I think we're a little bit behind time, and I think people do want to discuss these issues with regard to some of the consequences and some of the advantages or disadvantages of these various approaches. So the first one is simply to rest on existing constitutional guarantees. As we have seen, those are somewhat inadequate, and Prof. Shad has argued very well how those guarantees and powers ought to be increased. But let's bear in mind that under the Constitution as it is, there's still quite a lot of possibility and room for maneuver. Schedule 9 sets out not just the federal list, which is list 1, but list 2, which is the state list, list 2A, which is sort of supplementary state powers for Sabah and Sarawak, and then a concurrent list. So out of those 4 lists, 3 of those lists actually involve giving powers to Sabah and Sarawak. So a lot more use could be made of the concurrent list, for example, to confer more powers. Prof. Shad has also talked about the special fiscal powers and grants that these states are entitled to, for example, under Article 112 of the Constitution and under the scheduled grants as well. So there is a superior fiscal position, but as has also been argued, it's still inadequate because Sabah and Sarawak are still behind the rest of the country in terms of development, despite having a great deal of natural resources. Now, the special positions that have been already outlined to you are supposed to be guaranteed by a power of veto that the state governments enjoy under Article 161E of the Constitution. In other words, any constitutional amendment, let's say to the disadvantage of Sabah and Sarawak, could be vetoed by the state government, even if it obtains a 2/3 majority in the federal legislature. Now, as I see it, that is a very, very inadequate guarantee. It's, to me, very odd that this veto power is given to the state government and not to the state legislative assembly. Surely there should be a legislative debate about the exercise of such a veto power rather than giving it to the executive, which may very well be under the domination of the dominant party or coalition at the center, as has proved, in fact, to be the case throughout the period since 1963. So the general idea about the division of powers between the federation and the states is that this division should be policed by the judiciary, principally by the federal court, of course, itself. The record of the judiciary is not terribly strong in supporting the rights of states through litigation. Now, I know there are various initiatives in the area of litigation, but I think we should be cautious about our expectations of that process. It's not going to answer major questions. It may answer minor or procedural points, but is not going to be the answer to the problem of state powers for these states. So the practical outcome of all of these positions and guarantees is basically that none of these over 50 odd years now, has been successful in even maintaining the position that was agreed in 1963, let alone improving on that position. So I think there's a strong case for a rethink about these constitutional provisions and the guarantees that Sabah and Sarawak have. In particular, what we have seen over the last few decades has been federal manipulation of the state political systems. And I think that's been a very serious political and constitutional problem. As those of you from Sarawak will know, this goes all the way back to Stephen Kalong Ninkan's case in the mid-1960s. So the process of manipulation started right at the outset of MA 63 and has basically continued since that time. On the other hand, when you look at the Constitution, the definition of these various powers, it's not really an iron cage. There's a good deal of flexibility in the arrangement. This is quite complicated for me to explain in a short talk of this kind. But if you look at the articles in the Constitution around Article 76 and so on, you'll see that we can basically say that despite all the definition of powers and so on in the Constitution, if the state and the federal government are in agreement on any issue, then that can be implemented constitutionally in spite of Schedule 9. So, for example, executive powers can be quite easily delegated to state governments just by an agreement between the two governments. So flexible operation of intergovernmental relationships can bring very substantial benefits without any need to amend the Constitution as it is. So what about seeking fulfillment of the Malaysia Agreement? Now, as we've seen, this is a kind of a current aim, as with the constitutional amendment regarding the status of Sabah and Sarawak. And let me say here, I agree with Prof. Shad's analysis of that. It has been criticized as being purely symbolic and of no practical effect. But I would say that, symbols are actually very important in these matters, even if it's purely symbolic. And I think we've already seen that it isn't really purely symbolic. It does have consequences. It also has a great deal of potential in terms of what might follow from the fundamental distinction now reintroduced in the Constitution after being previously deleted, that distinction provides a basis for making further claims on the basis of the special position of the two states. So I think it does provide something like a platform or a foundation to make changes in line with MA 63. But litigating these issues, I don't think is likely to be terribly effective. I mean, notwithstanding the comments by Professor Shad, there are some areas where it is worthwhile litigating, and it may produce some results. But I don't think it can be regarded as a general strategy for resolving this entire problem. So political demands generally obviously need assent by the federal government. The point being that the interests of other states also have to be taken into account, not just those of Sabah and Sarawak, when the federal government makes its calls on the extent to which demands should be acceded to. And as I'm sure you all know, any constitutional amendment requires 2/3 majorities in both houses of the legislature. And therefore, in order to obtain any relevant constitutional amendments, as with the one that took place in 2021, you need to have a broad consensus and broad appeal across the other states, not just Sabah and Sarawak. Now, Prof. Shad mentioned the issue of representation, and I want to mention here that in addition to representation in the Dewan Rakyat, there's also the issue of representation in the Dewan Negara. And here there might be scope for change, because I think the Dewan Negara is ripe for reform. There have been many ideas floating around about reform of that body, and we've seen since 2018, just how important it can be. Was not important for many years, but now it clearly is important. And I wonder, going back to MA 63, if Sabah, Sarawak, and Malaya, West Malaysia are equal partners in the country, then shouldn't they have equal representation in the Senate? In a federal system, the upper house is supposed to be the guarantee of states' powers. And that was the original idea until the powers of the upper house were watered down by the introduction of a vast number, 44 appointed members, which are basically appointed by the federal government. That really prevents the upper house from carrying out this role. So I want to suggest, and I know there would be many objections to what I'm suggesting here, but I'm going to suggest it anyway, that with regard to representation, Sabah should have 33%, Sarawak should have 33%, and Malaya should have 33% of the membership. That is not proportional to representation, admittedly, but the point is to provide a guarantee that the Constitution and ordinary laws will not be made to the disadvantage of those states. And that's quite normal in federal systems, nothing to get terribly scared of. So, all right, what about the other strategy? You may think this is a kind of a contradictory strategy of seeking annulment of the Malaysia Agreement. And as you may know, in the last few days, a case has been filed in the High Court in Kuching to have the MA 63 ruled to be invalid because of failure to follow international law and basically to overturn the referendum that was held in 1963, about which, of course, there are many problems which still, I think, rancor with many people. And in this connection, people have made mention of the Chagos case in the ICJ in 2019, where there's a strong precedent for overturning a flawed referendum, even one that took place a long time in the past. However, I think it would be a mistake to get too worked up about the Chagos case, because, again, I don't have time really to go into the minutiae of this, but there are many bases on which the situation of the Chagos Islands and that of Sarawak and Sabah are quite different in this situation. But quite irrespective of that, I want to point out some of the realities involved in this kind of international litigation, because the Chagos case took 10 years from beginning to decision by the ICJ. And even now, 3 years later, the judgment has not been implemented. So, 13 years without any practical result, even when you win the case. And I think there are formidable obstacles towards winning such a case if this were taken forward for Sabah or Sarawak or both of them. In the meantime, over all these years, you would be neglecting or even prevented from fulfilling other ways of achieving autonomy. So I want to suggest that this is not a terribly good way of proceeding. In the current litigation, the idea is to have the MA 63 annulled, or in the alternative, fulfilled to its letter, which you may think is a rather strange way to present a case. It's a bit like the wife suing the husband for divorce and saying, well, if you won't give me a divorce, at least make sure that my husband will be a better husband. I mean, that's about the size of the case that is being pursued. So it's very difficult, I think, to argue these as alternatives. Are you supporting MA63, or are you trying to have it struck down? All right. Method number 4 would be to pursue a general decentralization of powers. And I think there's something in this, because Malaysia is actually, you may be surprised, one of the most highly centralized states in Asia, in spite of the fact that it's the only federal system, to the east of India. It's the only federal system in East Asia, and yet it is a highly centralized state, and it has been becoming even more centralized over the last few years. So Malaysia is actually the only state in the region that has centralized in the last couple of decades. And even back in 1957, all that was being given to the states was a measure of autonomy, a very modest kind of objective in the 1957 constitution. This has been balanced out, I would say, only by greater political pluralism since 2008, which has sort of revitalized powers existing at the state level. But for Sabah and Sarawak, I'm not sure that a general thrust towards decentralization would work, because these two states are asserting special powers, not powers that are congruent with all the other states. So as Prof. Shad said, if you want to claim equality in this process of decentralization, you may finish up actually losing powers rather than gaining them. Or if you do gain powers, you're only gaining powers that the center is willing to give to everybody, not to you in particular. And I think the whole point of the amendment is to say that Sabah and Sarawak are in a different position from the other 11 states. So that marker, I think, should be maintained, as has already been argued. Another problem is that once you start talking about decentralization, it might well introduce the issue of religion, which is a fraught issue in Sabah and Sarawak. So we might be in a situation where a debate about decentralization might spur people to demand increased status for Islam in the constitutional system, and perhaps even more centralization of powers over religion. So there is that problem with decentralization. On the other hand, general decentralization may be very beneficial for a number of other reasons. And note that decentralization involves local government, not just state government. So if you're interested in decentralization, you might want to be interested in how Sabah and Sarawak themselves can decentralize power to local government, along with local governments in the rest of the country. I think that would be highly beneficial, and a necessary ingredient here would be to reintroduce local government elections, which were abolished as long ago as 1965. Now, the fifth strategy, which is part of current strategy, but has actually yielded very little movement so far, is to demand special devolved powers. Now, this is irrespective of MA63. You can demand devolved powers that are in line with MA63, or you can demand powers going even beyond MA63. Right? Devolution, in this sense, is one of the advantages is that it's very open-ended. If you look at the example of Scotland, and I think people in Sabah and Sarawak do look at Scotland as an example. Scotland first had devolution 40 years ago. That has not stopped Scotland demanding more and more powers. And in 2015, they were given even way more powers than they had been given at any other previous stage. So devolution is not something that is simply fulfilled and that's the end of the story. You can continue to make demands and adjustments and get concessions under an open devolution arrangement. You're not bound by MA63. You can fulfill MA63, but you can also go beyond MA63. And I think this is a very flexible and very useful tool in the situation of these two states. And I want to make a strong point here, because there's a lot of misunderstanding about devolution, where people say that you can either have federalism or you can have devolution. This is not actually correct. You can have federalism and you can have devolution at the same time. You can have devolution in support of further federalism, in a sort of federalism all the way down system, as one American scholar called it. So it can be used in conjunction with other modes, such as the use of existing powers and general constitutional flexibility, which I mentioned, and does not contradict the idea of fulfilling the federal bargain. Also, it doesn't necessarily carry implications for other states. So it's probably politically less complex, because you can make demands based on your own particular situation, which may not necessarily be true for other states. As the UK has found with Scotland, Wales, and Northern Ireland, for example, you've got 3 different models of devolved powers. You don't have to give everybody the same powers. All of this may not even need any constitutional amendment, or even in some cases, legislative amendment, because to give you an example of how imaginative one can be, I'm aware that the medium of instruction in the education system in Sarawak, for example, is one of the claims that people want to make, that they should have the power to determine the medium of instruction. Now, legally, that can be changed simply by a ministerial order under the Education Act. It's just one of those subsidiary orders that is, filed in the Government Gazette. You don't need any legislative amendment, let alone a constitutional amendment, in order to bring that into effect. So I think these kind of loopholes should be exploited and looked at carefully. There are many, many of those. But at the end of the day, obviously, devolved powers do need cooperation of the federal government, as we've seen. And so far, obviously, in principle, people have said yes, devolved powers, but in practice, very, very little has actually been devolved. Even the claim with regard to the royalty on natural resources has not been fulfilled at this point, despite the promises to do so. Finally, and I know some people would be very interested in this possibility, complete secession from Malaysia, where you would have absolute powers to do anything that you like. Is this possible? Is it desirable? Well, possible, I think the answer is a sort of qualified yes, because after all, Singapore seceded from the Federation in 1965. But note that case required extensive agreements between the Singapore government and the federal government, and separating a territory off after 60 years from a federation is going to be an incredibly complex matter. Look how many years it's taken for the UK just to sort out all the issues with regard to leaving the European Union. Even now, those issues are not resolved. It's an incredibly complex process. So you have to engage the agreement of the federation, which is not going to be forthcoming very clearly. Otherwise, you have to do it in a violent way, and that is not going to be in anybody's interest. Is also going to be a very unpredictable outcome, and I'd have questions about the geostrategic or economic vulnerability of these states, and I'm basically not willing to recommend that Sabah Sarawak go down the route of demanding secession, certainly at this point. So in terms of general assessment, I'm bringing this to an end. I would say it use the existing constitutional flexibility to argue for fulfillment of MA 63, the maximization of powers under Schedule 9, experimentation with devolved powers, and if necessary, constitutional amendment, and take a look at the state veto and also the representation in the federal legislature. All of these viable solutions require a degree of what we call cooperative federalism. Federalism is not necessarily a sort of legal standoff situation. It actually does require cooperation to work properly. And also, I think we can think about the watchword of subsidiarity, that decisions should be taken at the lowest possible level, except where that is inconsistent with proper decision making. So if you want to see more about this, I've talked about devolution and subsidiarity in the article on screen, and James and I edited a book, 50 Years of Malaysia Federalism Revisited, in 2014, and those may help you to go further with these very interesting, important, and complex questions. Finally, I think the question should always be not what should be devolved to the states, but what should not be devolved. Everything should be devolved unless there is a strong case for keeping it at the center. That should be the basis of the discussions and the arguments. But I'll just stop there, and thanks very much. I hope I didn't go on too long, David.
Andrew, thank you very much. We are have to catch up on time a little bit, but that was excellent. Thank you very much. I will just let James have the platform now. James, please proceed.
Thank you very much, David, and a very good afternoon to all of you and my fellow panelists. I'd like to start off by thanking the Sabah Law Society for the kind invitation to come and spend this afternoon with all of you to talk about MA63. I'll just start to share my slides with you. Okay, so basically what I want to talk about is the political dimension of the Constitution amendments that was carried out last year, and what are the road ahead? How do we move ahead after the Constitution amendment? So my short talk will be basically divided into three separate areas. I think it's very important when we talk about MA63, especially the constitutional amendments last year, we need to put it within a certain political context. We need to understand how we reach the present moment, because it will tell us about how we're going to move forward. So in terms of the political context, I think we need to understand recent history, and we need to understand that grievances over the Malaysia Agreement has been around for a very, very long time, but it only became a political mainstream issue after 2008 general elections. What happened in 2008 was that basically, although Barisan Nasional won power, they found that they did not have enough MPs to stay on in power, and they had to rely on the MPs from Sabah and Sarawak. At that time, Sarawak was still under Sarawak Barisan Nasional, and they needed the MPs from both states in order to stay in power. Because of that, very quickly, Najib understood that he has to keep the people in Sabah and Sarawak happy. So Sabah and Sarawak were given additional allocations. And not only that, Sabah and Sarawak politicians were given very high-profile posts. So, for example, for the first time in Malaysia's political history, the Speaker of the Dewan Rakyat and both the deputies all came from Sabah and Sarawak. Najib also made sure that Malaysia Day was gazetted as a public holiday, and he openly said about the historical grievances faced by the Sabah and Sarawak within the Malaysian Federation. This is really, really important, because prior to that, the political leaders from Malaya has always sort of downplay what was happening in Sabah and Sarawak. So that was the reason why for a very, very long time, the Malayan political establishment saw Sabah and Sarawak as fixed deposit. In other words, we don't have to worry about what happens in Sabah and Sarawak. They will always vote for the Dutching. Now, this situation became almost unbearable after 2013, when they found that they even rely more on the MPs from Sabah and Sarawak to stay in power. This meant that they really had to step up and give Sabah and Sarawak politicians even more goodies. The most extreme example was that if you look at the 2008 cabinet, there was only one full federal minister from PBB, the mainstay party in Sarawak. But after 2013, 4 members from the PBB were appointed as full federal ministers. So you can see, they received a huge reward for helping Najib to stay in power. It was also during this period that the federal government started to actually do something in practice about the MA historical grievances. They set up a federal cabinet level committee to deal with the grievances. And also at the same time, the federal, on the state side, the Sabah government and the Sarawak government also set up state-level committees to deal specifically with the Malaysian agreement issues. The idea was that these three committees will meet together to sort out some of the key grievances. But of course, we know that the committee never fulfilled its work, because what happened was that in 2018, Barisan Nasional lost power to Pakatan Harapan. This short period when Pakatan Harapan was in power was extremely important in terms of Malaysia agreement. The reason I said that was because for the very first time since independence, issues relating to Sabah and Sarawak became one of the mainstays of an election manifesto. So if you look at the Pakatan Harapan election manifesto in 2018, you'll find that out of the 5 pillars of the election manifesto, one was devoted to Sabah and Sarawak issues, i.e. MA63. After Pakatan Harapan came to power, the law minister was appointed from Sabah, VK Liu, and he was specifically tasked to resolve the MA63 issues within 12 months. So basically, Dr. VK Liu followed the same process as what happened during the Najib administration, where he expanded the number of committees at the federal level. He added 2 other committees. And altogether, 21 issues were brought up. And at the end of Pakatan Harapan's government in 2020, 17 of the issues were resolved. Only 4 remain unresolved. One of the interesting things about the work of this committee, even though it was tagged as an MA63 committee, many of the issues raised in this committee actually were not related directly to the MA63 agreement. The other thing that Dr. VK Liu and the Pakatan government at that time was very keen on doing was that they wanted to change Article 1, subsection 2 of the Constitution. But they tried in April 2019. It was not successful. Many of the Malayan MPs abstained from the vote, but more importantly, the Sarawak GPS also abstained from the vote, and therefore the vote did not go through. My take is that it would have never gotten through, regardless of the party politics, because within the Pakatan Harapan government itself, the Prime Minister Mahathir was actually not in favor of granting more rights or power to Sabah and Sarawak. Part of the reason is because Mahathir believes strongly that in order to rule a country like Malaysia, to bring progress to Malaysia, you need a strong federal government. So you have an interesting dynamics in the government that while the MPs from Sabah and Sarawak were pushing for Pakatan to fulfill its election manifesto, the Prime Minister himself was not 100% behind this move to grant Sabah and Sarawak more rights. It's also important to look at the political context within the rise of Gabungan Party Sarawak, GPS, the ruling coalition. You need to understand that GPS support was needed when Pakatan Harapan fell apart and Perikatan Nasional took over in March 2020. In fact, without the support of the 18 MPs from GPS, Muhyiddin Yassin would not have been made the Prime Minister. And because of that, you can see shortly afterwards, Muhyiddin ordered Petronas, which comes under the direct control of the Prime Minister, asked Petronas to settle the sales tax issue with Sarawak, and also he issued an administrative circular calling Sabah and Sarawak Wilayah instead of Negeri, instead of states. Now, while this was happening, Perikatan Nasional itself was actually highly divided, because within the government itself, the Malayan political establishment was basically divided internally between UMNO and Bersatu parties. In the end, this tension led to the overthrow of Muhyiddin last year, but this had no political bearing on GPS and its bargaining power. In fact, I'll argue that with what we're talking about this afternoon, GPS actually became more powerful under the current government because in December last year, GPS won more than a landslide victory. They won 90% of the state seats in the Sarawak state elections. So this gives them extremely powerful level to use against Kuala Lumpur. Now, under this government, MA63 issues comes under another Sabah Minister, Max Onkili, but the deputy comes from Sarawak. The cabinet committee now is essentially the same structure we had under the Pakatan Harapan government, but more than 21 issues are brought up for discussion. Now, what is extremely sad about the current process is that, for whatever reasons, the minister have decided that the entire process must be secret. This is really, in my point of view, unnecessary and unhelpful. For example, the minister even stopped the publication of the Pakatan Harapan MA63 report. This is despite the fact that major portions of the report were already widely circulated among people in the political class. There's really no need to keep this process a secret, but for whatever reasons, the federal government, especially the minister in charge, doesn't want this process to be done in an open and transparent manner. Now, this is the part where I think is really, really important for the people of Sabah and Sarawak to understand. In the upcoming general elections, GE15, if UMNO and Barisan Nasional were to win a big majority, two-thirds majority, I can guarantee you the MA63 issue will be sidelined again. There is currently no political appetite among the Malay establishment in Malaya for more MA63 issues, especially anything to do with constitution amendments. For the Malay political establishment, most of them think that the 2021 amendments was enough to satisfy Sabah and Sarawak, and they are not willing to discuss further constitution amendments to grant more rights to Sabah and Sarawak. So the best case scenario going forward is actually for UMNO and Barisan to win around 100 to 115 seats only, and for GPS to win around 25 to 27 seats. This means that GPS will have enough leverage after GE15 to push for MA63 issues. Otherwise, as I mentioned earlier, the MA63 issues will be sidelined again. Now, what are the immediate consequences of the 2021 Constitution amendments? I think it was a political milestone, politically. This was the first time that the Malayan parties or the Malay establishment in Peninsular Malaysia have actually voted for a constitution amendment that only dealt with Sabah and Sarawak issues. Now, although this did not change the mindset about the MA63 historical grievances, it at least changed the way people living in Malaya look at this issue. It provides a way for people of Sabah and Sarawak to push for this issue and to tell them how serious it is and how this constitution amendment was needed. The other really important thing that came out of the constitution amendment, of course, is that for Sarawakians, who is a native will now be decided by the Sarawak government. Half natives will be considered Bumiputera under the Sarawak constitutions. And of course, given the fact that GPS was the one who brought the constitution amendment, they will have the bragging rights now. And I think this helped them indirectly in the December elections, and it will help them in the upcoming GE15. The other immediate consequences, of course, are highly symbolic. For example, Sarawak changed the title of the Chief Minister to Premier, and it is really to remind the rest of Malaysia that Sarawak is not a normal state in the Federation. Sarawak wants to be seen as a founding member, one of 3 founding members of the Federation. Now, you have noticed that since the Constitution Amendment was passed, Sabah has been much more silent. And this is in part because the ruling parties in Sabah are actually branches of Malayan political parties like UMNO and Bersatu. There's also not a single strong party like PBB in Sabah. So there's a lot less consensus on the issue MA63. And of course, because there's so many parties within the ruling coalition in Sabah, you will find that there's lots of petty rivalry between the different parties in Sabah. So in terms of looking ahead, what is the political wish list? I think the first one is really the budget issue. I think the other 2 previous speakers have spoke about this. Essentially, Sabah and Sarawak are looking for catch-up grants in order to bring more development to Sabah and Sarawak so that they can be on par with Peninsular Malaysia. in terms of the seats in Parliament, I think there was a widespread support in both Sabah and Sarawak to return the situation where Sabah and Sarawak control 1/3 of the seats in the Dewan Rakyat. And I think the previous speaker, Professor Andrew Harding, has addressed the issue of Dewan Negara. I think it's extremely important that the Dewan Negara is split into 3 separate portions, one for Malaya, one for Sabah, and one for Sarawak. I think in terms of modernization, I think moving forward, they're also looking for autonomy in key appointments. For example, there's always been a lot of unhappiness for a very long time that the state police chiefs are usually appointed directly by Kuala Lumpur, sometimes without any consultation with the respective state governments. This is really important because the state police chiefs are the people who control the physical security of the state. Same thing with the Royal Malaysian Armed Forces that are posted to Sabah and Sarawak. Very often, the head in both Sabah and Sarawak, the appointments are not consulted with the state governments. Now, the reasons why it's very important to consult them is because if you don't consult the state government, you made it very clear that these 2 persons, the head of the police and the head of the army, they're only answerable to Kuala Lumpur. They don't have to take into account the views of the state government. It's the same thing with universities in Sabah and Sarawak. The Lembaga, the board is actually appointed directly by the Minister of Education in Kuala Lumpur. So they will be looking at appointing people like the Director of Public Health Education. Right now is appointed basically by Kuala Lumpur. I think in terms of the state list, what Andrew was talking about, I think there is some movement or there's a lot of interest in adding new items to the state list. 2 of the one that is very obvious, and this was not considered back in 1962-63, is of course the issue of tourism and the environment. Increasingly, these 2 are becoming very, very important. And I think the state governments of Sabah and Sarawak really want this to be under the state list. Now, earlier on, I mentioned that, under Pakatan Harapan, there was 21 issues. 4 of the issues that were outstanding that could not be resolved. And those are issues mostly related to the oil royalty issues, petroleum cash payments, and the Territorial Sea Act, and the rights over the continental shelves. Now, I put it here as a political wish list, but I'm also of the opinion that these 4 issues cannot be resolved for the foreseeable future. The reason I said it is because the federal government relies on the money from Petronas for its entire development budget. And therefore, there is no way the federal government is going to give revenues from Petronas back to Sabah and Sarawak. They are probably quite happy to look at increasing the 5%, but it is not possible for them to give oil and gas resources in Sabah and Sarawak back to the states. The issues of IGC, I think this has been addressed by Professor Shah's presentation in detail, so I will not repeat them here. But there are also some specific issues for the individual states. In Sabah, I think the previous speakers, both speakers spoke about the 40% issue, and of course the PTI issue. The latest movement is, of course, is that they want to issue a PSS card to the residents. That is also very, very highly controversial. In terms of Sarawak, I think what they want is the federal government to recognize the OMO, the Oil Mining Ordinance. They want the federal government to also to recognize the territorial sea issues, return back to Sarawak. They also want more opportunity in the oil and gas sector. In other words, most of the downstreaming stuff from Petronas, they want it to be moved to the Sarawak National Oil Company called Petros. In terms of the specific, I think the Sarawak government is looking for more appointments at the federal level. For example, the Sarawak government is pushing very hard at the current moment for a Sarawakian or representative of the Sarawak state government to sit on the income tax board and other major statutory bodies. Now, on top of that, this is my personal wish list as we move forward. I think it's really, really important given the fact that we don't really have many legal cases related to MA63 in the Malaysian judicial system. We need people to file credible cases. Now, in recent times, there's a lot of excitement over the case filed in Sarawak by people trying to go into the courts to get the Malaysia agreement null and void. I've actually seen the paperwork, and it is my considered opinion that this case is not going anywhere. There's no way that this case can proceed the way it's currently written. So therefore, we really need more credible lawyers to step up and file more cases or different aspects of MS-63 in order to get a clear judicial results or clear judicial writings or opinions on sections of the MS-63. I would also like to see the Sabah and Sarawak legal fraternity work together. Right now, they seem to be working independently of each other, even on MS-63 issues. I think over the long run, I would like to see a new model for federal-state relations. The reality is that the Malay political establishment in Peninsular Malaysia, their natural instinct is not to grant Sabah and Sarawak real autonomy. They still remember the bad or the bitter feelings they had over Singapore leaving the Malaysian Federation. So there's a great fear that if they provide or if they give more autonomy to Sabah and Sarawak, eventually this will lead to Sabah and Sarawak succeeding from the Malaysian Federation. Now, in terms of decentralization, I think Andrew has really, Professor Hardin has really addressed that issue in detail, so I don't need to go through. But the point I'm trying to make is that we really need a new model for federal-state relations in Malaysia. Because without this new model, I think the same sort of issues that we're facing now will also come up in the future. The other point I always made is that I think we need more public education on what MS-63 and what is not. If you were to go out there on social media or on the internet, you find that there are tons and tons of materials written about MS-63, but a lot of them are actually nothing to do with MS-63, and a lot of them are actually not true. So I think we need more proper public education on what this is really about, how the Federation came about, and what MS-63 is and what it is not. Finally, I think it's very important that we change the narrative in this country over the long run. The Federation of Malaysia is not about Malaya, nor is it about a Malay Islamic state. I think we need to change the narrative in the long run. Otherwise, we will come back to the same issues about Sabah and Sarawak being special states in the Federation again and again. So quickly in summary, I think the 2021 Constitution Amendment is a historic moment, but at the present moment, it is still largely symbolic. Real autonomy is always in the details, and the key question that we still have to answer is the level of political integration in Malaysia. Because for the past 50 years, it is quite clear that the Malayan political establishment has been trying to push their style of politics in Sabah and Sarawak. They have been partially successful in Sabah by allowing mass migration and increasing the Muslim population in Sabah, but they've not been very, very successful in Sarawak. So because of that, Sarawak is taking the lead really in trying to put Sabah and Sarawak's position back at the proper place in the Federation. But unfortunately, Sabah politics is unstable, and the leaders in Sabah are really unable to create a state-based bloc in order to support the Sarawak position. My argument has always been the fight for autonomy is really a journey. And in the Malaysian context, I'll argue that it is a very, very long journey and we may never reach there. But the important point is, I think the future of the Federation really depends on the Malay establishment in Malaya. Whether we like it or not, the overwhelming majority of the population, the political class, all of them are based in Malaya. If they are strong, if the Malay political establishment is strong and united and can control the federal government without Sabah and Sarawak, then obviously there is no political will to deal with any issues arising from Sabah and Sarawak, even non-MS-63 issues. And therefore, to summarize, it is crucial that Sabah and Sarawak get 1/3 of the seats in the Malaysian Parliament and 1/3 or 2/3 of the bloc in Dewan Negara. Thank you very much.
Thank you very much, James. That's really enlightening on the politics, especially going on to the GE 15. Now, I'm going to pass the time right now to YB Barobia, and you can share now, YB.
Thank you, Dr. Fung, and thank you, Sabah Law Society, for inviting me to be part of this very high-powered panels. You all noticed that I'm the only one that is not a professor here. I think the three earlier speakers had covered most of the things that we all want to hear. But I'd just like to start here with the quotation from the speech of the first Prime Minister in Parliament on the 20th of April 1962, where he said, and I quote him, "When the Borneo territories became part of Malaysia, there will cease to be a colony of Britain, and there will not be a colony of Malaya. I thought I made it clear there will be partners of equal status," unquote. I think that's the crucial question we are asking at this webinar this afternoon. What does it mean when they say that we are equal partners, in particular for Sabahans and Sarawakians? Yeah? And what does it mean when the Article 1, Clause 2 of the Federal Constitution had been restored in our recent amendment in Parliament? Now, I propose to just respond to this from basically the political and the administrative perspective, secondly, from the economic and social, and thirdly, just to point out one or two very crucial points under the MA63. I'll be mostly sharing with you on statistic and facts, which perhaps would support and affirm what the other three speakers had said with us earlier on. On the first point, on the aspect of the one-third seat in Parliament, I think we all know that this had been watered down after Singapore left Malaysia in 1965, and which has really gone down for the combined number for Sabah Sarawak to, at the moment, about 25%. Now, interestingly, at this session of Parliament, many of the YBs from Sabah and Sarawak mentioned this publicly now, and they're talking about this. And I also mentioned this in my speech, and I said that, in fact, this would be the best time. And I agree with Professor James earlier on that, I mean, if UMNO BN were to win 2/3 majority in the coming G15, I don't think MA62 will be discussed and will be sidelined. And I said in my speech that this is the best time because the YBs from Sabah and Sarawak are the one that put the PN back in Putrajaya. And in addition to that, I think the law minister that we have is in fact from Sarawak. And secondly, I do agree too on the appointment of senators. The principle of 1/3 should at least be applicable to the senators as well. And we noticed that for Sabah and Sarawak, we have only the legal requirement of 4. And we hear of what Professor Sad had said. There are 44 appointments, and I think this need to be changed. Now, in terms of the appointments of top posts in the federal government and institution or agencies department, I'd just like to say a few, which is the reality. The appointment of ambassadors, for example, you know, we should, if we talk about equal partners, yeah. For the moment, the Malaysian embassy has 80 embassies worldwide. We have only 8 ambassadors and high commissioners from Sabah and Sarawak. Sabah has 3 and Sarawak has 5. And another example, we talk about the judiciary. We look at the judiciary. Federal court, we have 11 total judges and justices we have. Sarawak, we have only 3. Sabah, 0. Comprises of 20% of the total justices we have. Court of Appeal, we have 27 justices or judges. We have 2 from Sarawak, 1 from Sabah. Total 11.1%. High Court judges, we have 49 for the moment. Sarawak has 2 and Sabah has 4. Total 12%. And the JCs, we have 56. 4 from Sarawak and 4 from Sabah. Total 14% of the total. And I would agree with the proposed proposal too. I think Professor Saad had mentioned earlier on that the power for the appointment of the JCs had been taken away from the governors for Sabah and Sarawak to the Agong, and I would propose that that should be given back to the governors of Sabah and Sarawak. Now we have the others too. Top, for example, the Army, the Police, and the Navy. This would be very interesting. The armed forces for the last 50 over years since 63, we have 19 armed forces. Only one came from Sarawak, none from Sabah, ever. And the Air Force Chief is the same person that was appointed as armed forces. Now is the Air Force Chief for Malaysia, and is the same person from Sarawak. And we have 17 since 63. That's the only one from Sabah and Sarawak. Sabah again 0. Army Chief since 63, 26. Never even one from Sabah or Sarawak. IGPs, 13 since 1963. None from Sabah or Sarawak ever. So I'm quite certain those lower rank, lower than all these chiefs, would probably, in all probability, would be biased in favor of Malaya as well. So that's the statistic that we have so far. What about head of department in the federal government? Now the statistics shows that in Sarawak, for example, this is pertaining to the Bruneiization that had been agreed upon, where in fact it was agreed under MSCC3 that all the head departments of the federal government department in Sabah Sarawak should be headed by a Sabahan or a Sarawakian. For the moment, we have 103 positions in Sarawak. Only 64 are held by Sarawakians, 3 Sabahans, and 36 are still by West Malaysian. Now, on the federal service aspect of it, we just look at grade 54 above, interestingly. Sabahans consist of only 2.88% and Sarawakians 4.01%. Now, that's a huge disparity in that sense. Where is that, of course, equal partnership in that aspect of it? Now we look at the public universities and institutions of higher learning. I think we all know that we have only one university in Sabah and one public university in Sarawak. Then what about the rotation of the king? Can this be extended to Sabah and Sarawak as well? I think we never thought of that. But I think if you talk about equal partners, I think we should even demand for that rights as well. From the economic and social perspective, we always remember Tunku's statement much earlier, even before forming Malaysia, when he said that, and I quote him, that one of the principal objectives was to further the economic development of the Borneo territories so that their standards of living and technical skills might be raised in a firm basis provided for accelerated economic growth, so that the gap between a relatively backward state and the advance would be narrowed and not widened, unquote. Now we are, in fact, at the 12th Malaysian Plan, and the 8th Prime Minister admitted to the fact that there is this development imbalances between East and West. And I believed, we're looking at what is going on, Sabah and Sarawak probably are 20 years behind West Malaysia in terms of economic development. Now we look at the 12th Malaysian Plan report in 2019. The incidence of absolute poverty in Sarawak was 9%, which was above the national level of 5.6%. And in fact, in my speech in Parliament last year in September, I proposed then that in order to help lift the rural population out of poverty and increase their living standard, we need to provide them with good infrastructure, including roads, water, electricity, internet coverage, healthcare, and solid education. And in fact, if you look at Sarawak, it's appalling to discover that only 13.4% of the rural population had tertiary education. And there are many factors that contribute to this, like long distance to school, lack of good roads and transportation, poor schooling facilities. Instead, government, in fact, identified that there are 1,020 dilapidated schools in Sarawak. We have the shortage of 3,385 teachers as of July 2021, lacking of internet, laptops, and etc. Now that we are teaching is made online. And even when we look at the GDP per capita of Sarawak is, in fact, 46,800, and considered to be second to that of the central region of Malaysia, which is 62,900. And yet Sarawak is the third poorest state. Obviously, this is unfair distribution of the state wealth. So I believe with good road connectivity, economic activity, good road, good connectivity, I believe economic activity will follow. And coupled with better education and healthcare, the opportunity for our rural people to improve their lives will be brighter. I'm sure that is true of Sabah as well. So for this reason, and in the light of this topic that we are discussing, I would in fact propose that Sabah and Sarawak should be given back full powers over the flowings. 1, infrastructure, 2, education, 3, health issue, and 4th, the issue on the studentship and part and parcel of the power of the home ministry should be given back to Sabah and Sarawak. And we all know that the stateless children issue is now a big issue for Sabah and Sarawak, and even in this parliament sitting, it has been raised by a lot of YBs from East and West. So in line with this too, of course, the thing that need to be done, then if this is given or devolved to Sabah Sarawak, then of course we should be given the rights to collect taxes in regards to this area, and I think it would be equivalent to the budget or the taxes that have been allocated to these headings in the past or in our annual budget. And that should be how it should be, to me, be implemented if we need to. Of course, the other aspect that we can utilize and exploit here would be that had been raised by Professor Shad on the special grant under Article 112C for Sabah and Sarawak. And we noticed that, in fact, the 16 million allocated to Sarawak since 1969 had never been reviewed for Sarawak. And in fact, the PH government had planned to increase that to 32 million and double it in 2022. But unfortunately, that was not be the case. And we hear of this Sabah status. I think Datuk Maximus Ongkeli stated in the paper in February 18 this year that for Sabah there is a review. In fact, they were thinking of a 5-time increase in Sabah. So that would be one of the areas and the means of how Sabah Sarawak should be given that privilege or leverage. We look at the annual budget itself, and I think this had been raised also in Professor Shad sharing earlier on. In fact, the national development expenditure for the 12 Malaysian plan is 75.6 billion, and it was promised that Sabah and Sarawak should receive 15% of this, which should be around 11.34 billion. But sadly, as I think correctly stated in Professor Shad sharing earlier on, it only 9.8 billion. 4.6 billion for Sarawak, which is equivalent to 6%, 5.2 billion for Sabah, equivalent to 6.8%. Shouldn't we get on 30% at least, if not half, lah? Yeah, so that is how I think unequal it is there. That is very obvious to me, and I think the next point that had been also raised up and shared, emphasized by the three other speakers, I think is on the peculiar status of Sabah Sarawak in terms of, one is the issue of freedom of religion. I think that must be maintained, be emphasized. Sarawak in particular, until now, maintain the fact that it has no official religion, although Sabah had changed its status in 1975 or 76, I think. That the second is the language issue, where English had always been used, and until now, I believe that Sarawak, as far as I know, we have not passed any law in the assembly to change that status. And finally, I think Professor James and also all the, I think Professor Andrew and Professor Shad also mentioned about Territorial Sea Act and the Petroleum Development Act. I think these two legislation is very obvious unconstitutional to me, and the issue of rights over our petroleum, oil and gas in our waters, territorial waters and continental shelf is a big issue, and I think this is one of the areas where the legal fraternity would probably be interested in taking in. I know that the state of Sarawak had filed a case earlier on. I think something to do with the challenging of the Petroleum Development Act, but finally it was settled halfway, and we're supposed to receive some kind of compensation on that settlement. So question, of course, is when, whether this can be implemented. Will there be any change in the coming years after that amendment? I totally agree with Professor James. If UMNO BN were to win in G15 with 2/3 majority, MSCT will be sidelined. And I don't think they're interested in this. That's why I very believe that this would be the best time for the people, the people representative from Sabah and Sarawak demand that this be implemented, because they are in fact the kingmaker as far as the federal government now is concerned. So I'll just leave it there, Dr. Fung, and I think we'll give more time for people to respond to this. Thank you so much.
Thank you very much, YB Rupian. I think with all that, of course, our time, we have taken, overstretched our time already. But with the liberty of our audience, I think you are still all here. There are many questions that have come in, but let me just perhaps just summarize one or two, and then I will just pose it to the panelists. I think this whole thing about devolutions have come in. There's questions on even more liberty in the immigration matters in Sabah and Sarawak. I think devolution, the speakers, you all have agreed that it's something that has to be done, and it is a piecemeal matter, right? All right. Can I just direct this question firstly, to Andrew, right? You have mentioned that it's true cooperation, but how in practical terms, after James have mentioned about the reality of the politics, right? That if they have 2/3, they will not be interested, you know? I mean, there's no will, all right? I mean, so how do we move it on from here on? Could you answer that?
Well, I think that's really a political question, and I think James is quite right about that. What really puzzles me about this situation is that we're in a unique space. since 2018, where the members from Sabah and Sarawak have actually held the balance of power. And in theory, they ought to be able to extract, concessions from either coalition. I mean, they have, when you're the kingmaker, you're in a very strong position to make those demands. And there is a danger that this unique situation may suddenly disappear later in the year. Although I think a 2/3 majority is still a pretty big hike for even the BN to make in the present political circumstances. So unfortunately, it looks as though this opportunity is kind of slipping away. And once it does, it's going to be a long time before it comes back. I wish there were a more positive answer to give.
Thank you, Andrew. James, can you respond to this? This seems to be a window of opportunity right now where we are, right? What are some of the more concrete steps that can be taken now?
Well, I think the key concrete thing that people in Sabah and Sarawak are really looking for is to resolve the issue about who actually owns the oil and gas resources, because ultimately that really leads to the money issue. But as I mentioned in my short presentation just now, there is no way the federal government can give the money to Sabah and Sarawak. First, they don't have it. Secondly, they need the Petronas money for the development portion of their budget. So without Petronas, there is no development for the rest of Malaya. So there's no way they're going to negotiate that. The only thing that they can move forward on is that, Sabah and Sarawak will have to get some sort of guarantees from the government, whoever comes in after the middle of this year, that this issue, MA63, will still be on top of the political agenda. The way it was in cabinet, and I think YB Baru can enlighten us a bit more, is that right now the ministers from Sabah and Sarawak are overrepresented. But the problem with the way the cabinet works is that it really depends on how willing you are to speak out and push for it, and whether you're united on the cabinet table. Of course, I'm not a member of cabinet, I've never been there, but it is my understanding the present cabinet, I'm talking about the present cabinet, most of the Sabah and Sarawak ministers are not that united on certain issues. But I'm saying that on this issue, perhaps they can actually force the federal government to get something in writing, because a lot of things, as Professor Andrew has mentioned, a lot of things can actually be done through administrative edicts rather than constitutional change. So things like education, right? I'm sure a lot of the people watching this knows that the Sarawak government, a government itself, is actually getting involved in private education because they're building 6 international schools, to provide English medium education. So it is possible to do a lot of things. But the bigger problem is, as I also mentioned in my presentation, there doesn't seem to be any unity between the politicians in Sabah and Sarawak. I mean, on paper, both Sabah and Sarawak are actually facing the same issue. But when it comes to get things done, right, the Sabah politicians are doing their own thing, the Sarawak politicians are doing their own thing. So to me, right, a lot of them are actually caught up in petty politics. And as long as you don't have a clear unity between the politicians of Sabah and Sarawak, you leave room to be exploited by the Malayan political class. And that's what they've been doing, especially with Sabah politicians since the 1980s.
Thank you, James. Baru, you see, since you have the amendment now, okay, you mentioned that we agree that this is just not merely symbolic, it's an important step that you have taken on, right? Now that at least place Sabah and Sarawak on a different basis, even if you're talking about devolution. Right? Let's take for education now, right? There's a question on how do you get the history of MA63 to be a compulsory subject for education, to get it onto the syllabus, so that this part of the nature of our nation is actually not just an administrative act, but something that's there for the whole country.
Yeah, I think I agree with Professor Andrew earlier on. In fact, this can be done by administrative directive. we know that education is in federalist, and that's a problem. Now, fundamental to all this, I think, is the political will and the understanding and I think the pressure and the unity from Sabah and Sarawak to deal with this, which President James said in the cabinet itself. I mean, if you can be united, in fact, as I said, this is the best opportunity, the best time for the Sabahan and Sarawakians in cabinet to make that stand. I can see any other time that will be, you can implement this. So that can be done that way, unless of course there will be an amendment, an agreement that will be pushed to the stat list. That is how it should be done, as I see it. Yeah.
Now, apart from just at the cabinet level, right? Since we have the amendment already, right? How do you build on it in the law? I think Andrew has mentioned that legal cases probably not the way to go. But let's take the case in Sarawak now, right? Because if the rights of Sabah and Sarawak are ignored all the time, basically, if you take the analogy that Andrew gave about a marriage, you stay there, and there must be the fairness in that relationship, or we might as well call it a day separation. How does that add into this mix now, which we're in? I'm talking about the recent Sarawak court case. How does this assist still in this equation?
Professor Fong, I think I'm very attracted to what Professor Shad mentioned in his slide, where he said that the IGC and MSCT had now been constitutionalized.
Yes.
That's very interesting. Now, the case that he referred to among the Kuruntung and Peru Masanda, that happens to be my case, the Peru Masanda, where we argued that the panel in the Court of Appeal, and the federal, if there's any case that comes from Sabah Sarawak, at least there will be a judge from Sabah and Sarawak to hear that. And when we argued that out in Peru Masanda, that was not, as Professor Shad put it out, not the legal requirement. But now, with this amendment, it appears that it has been constitutionalized in a sense, legalized in a sense. So maybe we can take that from that aspect, looking at the IGC and all the discussion and the minutes of in the reports that we can piece together to support any legal challenge now. And that's how I look at it. And that includes the Territorial Act and the PDA 1974.
Yes, those are the questions asked also. You see, James, in litigation, if those matters are taken out each case at a time, because it's if you just take the significance of this moment, MS63 has been constitutionalized. It's an agreement, right? It's agreement is meant to be performed, isn't it? Right. So if the rights of Sabah and Sarawak have been ignored for so long, right? You either perform it, or otherwise, it's a matter of we move on from here, because that would feed onto the political scene, isn't it? Because that's an alternative. You perform it or not. You look for separation. What do you have to say to that, James?
I think the way to look at this issue is that the thing about MS63 with this sort of agreement, right? It is not purely legal, it is not purely political, it's a bit of both. But in the Malaysian context, at the end of the day, a permanent solution has to be a political solution. There is no way out of this. You can sue left and right and do whatever you want, and you will get, you get a legal answer to certain parts of it. The point I was trying to make in my presentation was that the current suit that you're talking about, the one that's happening in Kuching now, I've actually seen the paperwork, and I can tell you that that suit will fail. It will not even pass the initial stage. what is more likely to pass is you file a suit that deals with individual parts of MS63. Because one of the problems we face as a lawyer, you know this, is that a lot of people have tried, but they could not overcome the local standing argument. So unless you get past the argument, I think it will be very difficult. But there are certain things that you need to do at the same time. For example, in the judicial appointments and all the key personnel that YB Baru was talking about, you need to put all those people in place first. And you really need to look at MS63 as a long-term thing that over the long run, you need some sort of a new federal-state relationship. Because basically, the system that was set up in 1963 is not fit for purpose anymore in the 21st century. So if you look at it from that perspective, you can understand where I'm coming from. That at the end of the day, this is a political issue. Although there are legal implications, at the end of the day, it is a political issue.
Okay. All right. Andrew, anything you want to say to this?
I mean, only that I agree completely with James. I mean, the legal strategy is only going to deal with rather narrow issues and maybe some issues of principle, but it's not going to solve the total question. I mean, I think that was the thrust of my entire presentation, is that at the end of the day, you have to have political agreement. And I think a lot of this litigation is not so much to win the case and the legality of it, it's just used as a strategy to sort of publicize a political position. It's a kind of posturizing. And I think, you know, that this has become a very common thing in Malaysia over the last 20 years, that nobody takes your word seriously unless you have a writ behind it, you know. And then you find after a while that, you know, you never hear anything more about that writ. The case never gets to court, or if it does get to court, it's thrown out very, very quickly. I share James's skepticism about litigation as a strategy within limits in certain areas for certain purposes affecting individual rights, you know, quite possibly. But, you know, I don't think it should be really used as a kind of publicity stunt.
Yes, I just want to, if Professor Shah is anywhere in this, if he has any comments to make on our discussion, he's most welcome to just speak to us. So I think with that, we're coming to 5 o'clock already. I think what is the way ahead is some cooperation with the state and federal, but of course the stronger position of Sabah and Sarawak at the moment, the representations. So this matter will be all the committees, like James, you mentioned the 17 points, issues have already been agreed for it to move forward. The litigation piecemeal would be important, right? Because it deals with specific issues and is also something that the state and federal government themselves will look at, right? As for the local standpoint, I think the position has been strengthened. The fact that MA63 now is expressly mentioned, I think YB Barobian has mentioned that, even the cases that we are on a stronger footing in that sense. I think we were agreed on that. So I think that maybe we can end this on a not necessarily negative note, right? It's positive. Right? The way ahead is actually positive. With challenges, impediments, but with trepidation, I think we can take it forward that way. You know? So that is not a bad way to start 2022. And with that, I think I want to thank all of you. Thank you very much for participating and all the slides. This is under recording. Those who couldn't join, will be asking for the recording. And I've certainly enjoyed it. I've learned a lot from all of you, and can, well, thank you very much. And for all the audience who are with us, you can join me in thanking our esteemed speakers, including Professor Shad, who's not with you, but you've seen his thoughts in the slides. So with that, thank you very much. Thank you very much, Professor James Chin from Tasmania, Professor Andrew Harding, you're in Malaysia at the moment, yeah, and Boy B. Barubian, and Professor Shad, and for the Sabah Law Society, your enthusiasm for this forum have encouraged us, and we hope to continue with this. All right. So have a good weekend. All right. Bye-bye, everyone.
Thank you, David.
Yeah.
Bye-bye.
Thank you. Bye-bye.
Bye.
Thank you, speakers and Sabah Law Society. Dr. David Fung, thank you.
Thank you, everybody.